Good afternoon, everyone, and welcome to Turnaround Talk's second roundtable. Before we continue, please can we take note of the house rules? All participants, with the exception of the panelists, are kindly requested to switch off their cameras and to mute their microphones for the duration of the roundtable. Please make use of the chat function to ask other panelists questions, and I will be presenting these questions at the end of their presentations. Panelists, please stick to your allotted time for your presentation. So there are a lot of legal requirements and frameworks that govern business rescue. Joining me today are three of the top future legal experts, and they will be discussing the current legal landscape that governs the business rescue industry, as well as what the future landscape will look like. Let's start with Roxanne Webster. Roxanne is a senior associate at Worksman Attorneys. She specializes in business rescue, commercial litigation, as well as advising on insolvency related proceedings. Over to you, Roxanne.
Thanks, Jonathan. Let me just share my screen. Can you see my screen? Okay, perfect. Thanks, Jonathan, for the opportunity. I must say that Turnaround Talk has quickly developed and established, and I'm happy to be part of the discussion and this contribution today. As Jonathan mentioned, I'm a senior associate at Worksmans. I specialize in contractual disputes, dispute resolution, and also business rescue and insolvency. I think business rescue is the topic of today's discussion. The topic today is current and future legal landscape influencing business rescue. It's quite a wide topic. So what I just thought to discuss is important considerations that we can all take into consideration of what the current and legal landscape is today and how it's affecting business rescue. So the current legal landscape, as we know, business rescue is in part of Chapter 6 of the Companies Act. And if we think about it, business rescue has been around for it's been around for 13 years. And business rescue practitioners and attorneys have had 13 years to actually get to know the law and practice it. But whether this 13 years is actually sufficient is another debate on its own. But the point is that it's been around for quite some time now, but only recently. Only recently have we seen that the public has become more aware of the process and has started participating in the process. And this is simply because we've seen in the past 3 years, big companies going to business rescue. For example, we've had Edcon, we've had ComAir, Ster-Kinekor, Mango's the recent one, Fairmont Zimbabwe Hotel, and these are all names that the general public will know, and therefore have started taking knowledge and cognizance of the process and what it actually is and how it can possibly save their jobs. But with public awareness comes more participation by employees, and I think that's something we really need to consider. For example, in the Denel situation, I think we've all been looking at Denel closely and watching it closely. And there we saw an employees association bring a business rescue application to place the company into business rescue because the company was dragging its feet and not doing anything. But this just shows you the level of knowledge that people now have of the business rescue process and what it can actually do, and that potentially it can save their jobs. So this is something we need to consider going forward, both as practitioners and attorneys, that we might be faced with applications by employees or trade unions seeking to place companies into business rescue where business in distress have failed to take the necessary or file the resolution to place themselves into business rescue. And what would then, if you're acting for a large creditor, what would you then do? You would need to know this process, and that section 1317 allows for you at the first meeting of creditors, if the company is successfully placed into business rescue by employees, it allows you as the creditor rights to, at the first meeting of creditors, either ratify that nomination or seek to appoint a new business rescue practitioner. Another important consideration, I think, that comes with public awareness is more media reporting on business rescue. I think we've seen in SAA, there was a lot of media reports about business rescue and a lot about business rescue fees. Now, business rescue practitioners' fees have been a hot topic for very long. But in there, we saw that topic go to Parliament. It was spoken at Treasury. So we need to be more cognizant that business rescue is going to be more in the media, and business rescue practitioners need to be more cognizant of that and what appointments they do end up taking. But apart from that, the current legal landscape, I think I can describe it as fairly settled. Many people might disagree with that, but I think we're at a point where we know what the process is, we know what the rights of creditors are, we know the areas that are susceptible to abuse, but there also are novel issues that creep up often where we need further interpretation or case law to assist us. But generally, I can say that the current legal system, and together with a plethora of legal cases, has settled our current debates and has made business rescue developed in such a way that companies, especially these large companies, can feel confident to go into business rescue and make the informed decision to go into business rescue because they've seen that there is a success rate that is developing. And I think South Africa is doing quite well in this area of the law. And they're making full use of business rescue. I was speaking to another colleague in Mozambique, and we wanted to institute business rescue proceedings for a company in Mozambique. But he said to us that although their Companies Act allows for it, they have never ever practiced it. So I think from that perspective, South Africa is doing quite well in advancing this. And also it generally assists the economy as well to recover from this pandemic. Then moving on to I've just jumped ahead. Moving on to the future landscape. So my discussion here is going to center around simply SAA. It's, as we know, it's the first state-owned entity to go into business rescue, and there's a lot that we can actually talk about there. The first point that I think it signals to government that it's a viable option for state-owned companies. And we might now start seeing more state-owned companies going into business rescue. It seems like Denel, we were all watching for Denel. It seems like from the recent reports last week that Denel settled its liquidation application and didn't find it necessary to pull the trigger and place it into business rescue. But it is something that is seriously being considered by government, and I think we will see more of this. It's also an important consideration because in the first, we've seen, we might say that it was one of the biggest business rescue where we've seen a large workforce, where SAA had about 5,000 employees, and only 1,000 of those employees in terms of the business rescue plan were retained. The others were all retrenched. So obviously with that comes a lot of labor disputes, a lot of labor pushback. And this is an interesting one where we saw one of the matters that went right up to the Labor Appeal Court, where the Labor Appeal Court said that in terms of Section 136, retrenchments must now be a part of the business rescue plan. It must be contemplated in the business rescue plan, and voluntary severance packages should be considered prior to retrenchment. So this is a new interesting debate that has arisen, and it's for us as legal practitioners and business rescue practitioners to see how we work around that. Also, another interesting concept that has come up in SAA is the concept of receivership. Now, receiverships, it's used in other countries as a debt recovery solution, but in this instance, it was used similar to a Section 155 scheme of arrangement, where the company exits business rescue, but a receiver is appointed to deal with the claims of the business, the claims in terms of the plan, because the SAA process envisages claims only being paid out within 3 years. So it's a process now that's being used where the company can exit business rescue, but the receivers are still appointed to deal with claims. So we might also see more of that going forward. It's also possibly our first test case for privatization. And this is probably going to be very topical going forward. But now we've seen that SA, the first state-owned company, is being privatized through the Katiso conglomerate, and they are in their advanced talks concluding their deal. So it might also, as we'll see more SOEs going to business rescue, it might also be an avenue where these SOEs can be privatized. It also introduces the interplay, I think, between the Companies Act and the PFMA. Now, we all know that the PFMA is to guard against wasteful expenditure, etc. But in a business rescue scenario, the difficulty that I've seen is also which institution is a business rescue practitioner accountable to. In terms of the PFMA, it limits what the business rescue practitioner can do. So he must first obtain authorizations for alienation and encumbering assets and concluding future financial commitments. But in terms of the Companies Act, it allows the business rescue practitioner extensive management powers. So there is an interplay that will need to be worked out in future when we see more business rescue of state-owned entities. And that's my presentation.
Awesome. Thank you very much, Roxanne. Coming up next is Jessica Osmond, who is an associate at Cliff Decker Hofmeyer. She specializes in business rescue, restructuring, and general commercial litigation. Jessica, over to you.
Thanks, Jonathan. I'm just going to get my screen up. Okay, I'm assuming you can all see my screen. But yeah, thank you, Jonathan. Thanks once again for the opportunity, and yeah, thank you for the introduction. I think, as Roxanne alluded to, business rescue has been around now for many years, and so I think, although there were some kinks in its inception, I think in considering the current and future landscape of business rescue, it is important to go back and in fact consider where it all started and how far it's come, as a mechanism and process since its inception. And so if I can look at, since Chapter 6's inclusion in the Companies Act, the business rescue process there seemed to have been, as I said, a lot of teething issues. There was quite a slow uptake in making use of the business rescue mechanism in many respects. I think a lot of it due to industry hesitancy. As Roxanne said, even in Mozambique, people are, although it's provided for in the Companies Act, it hasn't been used. And I think the slow uptake in the beginning was as a result of the negative stigma and which business rescue seemed to have carried throughout the years. I think this came as a result of a lot of bad press, so to speak, and with more and more of it being in the media, it's often heard, as Roxanne mentioned as well, things like BRPs charging excessive fees, employees not getting paid throughout the process of the business rescue, or not knowing, being left in the dark as to what is happening, major delays in the payments to creditors, frustrating the process. And so I think a lot of this led to people formulating, sort of a misinformed understanding of business rescue and a hesitancy to fully explore the intention of what business rescue as a rehabilitative mechanism for distressed businesses was in fact intended. However, fast forward a few years, and we've seen that, business rescue has developed and streamlined, and the uptick in the election to undergo the business rescue process has seen many businesses rehabilitated back into the economy with far less drastic measures needing to be taken, which in turn, as we've seen in industry, has just had a positive knock-on effect on all stakeholders and interested parties, including that of employees of distressed companies. And so the negative stigma, it seemed to have waned over time in comparison to the backdrop of the alternative option, which is obviously a liquidation process. And so I think business rescue is slowly but surely being accepted as the lifeline for which it was intended, for struggling businesses. And yeah, I believe that this development and streamlining of the process is largely owing to the court's intervention, where we've seen the court grappling over the last couple of years with many issues that have arisen from the implementation of the mechanisms provided for in Chapter 6. There've been certain grey areas, certain kinks that have had to be ironed out. And we've also seen over the past couple of years, the courts clamping down on the duties and obligations as expected from business rescue practitioners. We can appreciate that in terms of, in accordance with Chapter 6, business rescue practitioners are given quite a wide scope of powers in running the business and trying to rehabilitate it. And so I think it's only fitting that the courts have noticed this and given more onerous expectations of good faith expected from a business rescue practitioner, so as to ensure that in the instance where there really is no reasonable prospect of rehabilitation, that the proverbial can is not kicked further down the road simply to write a fee, which I think was the initial concern, since business rescue's inception and people's either misconception or conception that people had regarding the business rescue process. And so I think that the development over the years has allowed people to accept and appreciate that the business rescue process is not merely an inevitable prequel or a prequel to an inevitable liquidation, but rather a means to avoid a liquidation as far as possible, as it aims, obviously, as we know, to rehabilitate a financially distressed company. And this has particularly highlighted the need and importance of ensuring intersector collaboration in endeavoring to rehabilitate and recover a business in order to reintroduce it back into the economy. And so bringing us to the present day and appreciating where the business rescue process first started and understanding the process, we've noted that whilst the COVID-19 pandemic has had devastating effects on the economy the world over, it's also acted as a catalyst in the business rescue sphere for intersector collaboration in the business rescue process, and in ensuring that the business rescue process is seen now more as an all hands on deck process, where experts from various different sectors, you'll have competition, employment, litigation, finance, restructuring, all coming together to ensure the revival of a company in distress in order to consider and honor the interests of all, various stakeholders as directed in the Companies Act. And so with this uptick in the volume and the complexity of the business rescues in the last 1.5 years, Roxanne mentioned a few. The most recent, we've got Mango, we've had SIA, we've had, Denal. Over the last couple of years, the courts have now continued to grapple with and assist in resolving these issues. And obviously with the more complex business rescues, there have been some grey areas which the courts have actually addressed. And so these often arising as a result, I think, of the overlap and the intersectoral collaboration. I think, when you've got various sectors, that's, the courts often needs to step in and clarify, various issues. And so I believe that this has caused for an evolution of the process in many ways, as the courts have been faced with more and more crucial issues pertaining to the mechanisms and procedures as provided in Chapter 6. And it's, the court's intervention has provided valuable guidance in making the business rescue process a success. One practical example, and I know Roxanne also mentioned it, was that of the SIA business rescue, where where SIA saw the inside of both the Labour Court and the Labour Appeal Court a few times last year. And I won't go into the case, but both the Labour Court and the LAC in that instance were called upon to intervene in the business rescue process, so as to ensure the rights of the employees were protected, as well as in as far as any other stakeholder should have been protected, insofar as the labour laws allowed, while still considering the provisions as provided for in the Companies Act. And so in this instance, in considering that section 1361B of the Companies Act, a BRP is now not entitled to implement any retrenchment process or workforce restructure until such time that a business rescue plan has been adopted and that retrenchment, is in fact contemplated in the plan. And so I think that this has caused for a lot of, it did cause for a lot of reflection and debate within the insolvency sector due to the fact that BRPs at the time, it was seemingly now that they were under a more onerous obligation to seriously contemplate the interests of the workforce employees when drawing up a business rescue plan. And it seemed as though business rescue practitioners were kind of left with a lot less options available in managing post-commencement operating costs relating to human resources expenditure, which, as I'm sure we can all appreciate, in many instances, this is a company's biggest expense. And so it's cause for business rescue practitioners to have to be a bit more creative, consider various different options in the business rescue process, as well as then get the input from experts in various other sectors. We saw that was in fact the case. I mean, it was mentioned in the SAA case regarding the voluntary severance packages, as opposed to considering a retrenchment. And then, we also saw the renegotiation of employee terms and conditions in accordance with section 1361A Roman numeral 2, which we saw in the Airline Pilot Association of SA versus SAA case, wherein SAA was able to enforce a lockout in the instance that employees were not willing to renegotiate their terms and conditions. And so these contemplations and changes, once again, just calls for a shift in the landscape of business rescue process going forward. And so with this continuous development and shift in the process and industry, business rescue seems to be, as Roxanne said, it seems to have settled. People seem to have bought into the idea, and it seems to have been used more and more. And the expectation of specialized advice and assistance through collaboration has been evident, owing to the complexity of the rescues that we're seeing, more and more. And in addition to the element of complexity in considering the increase in filings, there's definitely a need, I believe, for more expert business rescue practitioners to enter the field in order to manage these complex rescues, which require obviously further collaboration and buy-in from the various sectors. And so, I think in considering the future landscape, I think we look forward to, the benefits of future successful rescues, and that they're felt by not only the stakeholders themselves, but the economy at large. So, thank you. Thanks again.
Awesome. Thank you very much, Jessica. Finally, we have Johan Els, who is an experienced legal consultant and specializes in tax law. Johan, over to you. If you could just enable your video so that we can see you and unmute your microphone. Yeah, thank you very much. Over to you, Johan.
Thank you. Good day to everybody. Sorry, I must apologize that I'm unfortunately unable to share my presentation with you for some other reason. And then also we appear to have load shedding in the area. So if I do disappear, I'll try to log on back on as quickly as I possibly can. But unfortunately, that's the nature of the beast that we're dealing with these days. In terms of SARS and business rescue, SARS brings a completely different flavor to business rescue. And the firstly is they're kind of a different type of creditor. Although the case law says that SARS is an ordinary creditor and has the same powers of recovery and enforcement action as any other, SARS takes a little bit of a different view. They have legislation in their hand which they can use to demand compliance and to ensure that they recover whatever they can from a taxpayer, what they should. It's important to know that in terms of business rescues, SARS look at section 193 of the Act. And in terms of that provision of the Act, SARS is obliged to assess, collect, and not to forego any portion of tax. Now, already you sit with a situation with business rescue where a taxpayer has filed for business rescue and there's a substantial amount, in my experience, there's a substantial amount of taxes due and owing, specifically pertaining to VAT and pay-as-you-earn, which is statutory taxes. And SARS holds the view that a taxpayer like that is actually a quasi-collector, or it's type of tax collector on his behalf, And there's no reason for that taxpayer not to pay those taxes over to SARS. However, that's not ordinarily always the case. So SARS then tries to use all and every measure to engage the business rescue practitioners, and they find themselves further in this predicament due to the Beginsel case that says is that SARS, other than in liquidations, in business rescue is a concurrent creditor. So they stand a little bit at the back pocket, and they need to wait after all secured taxpayer creditors has been paid their dues. They need to wait for their dividend at the end of the line, and obviously that would be a lesser amount than what they would ordinarily would receive. You sit then with a situation that SARS, in the recovery with this taxpayer, it's got a compliance history. It's already been non-compliant. Often it's returns that's submitted without payment. And then you sit with a further predicament for SARS in terms of how do they deal with audits and assessments that was pending at the time of the company filing for business rescue, and then what would be the position if that company that's in business rescue files or intends to file a dispute against that assessment, and that ordinarily would delay the business rescue proceedings, and obviously postponements in the voting rights of SARS would be affected. It makes it difficult for SARS to, on a first creditors meeting, to say, I can confirm my claim on the following form being, it's definite and certain on the basis that returns were submitted or assessment was raised. However, there's still a contingent liability in terms of audit and assessment that needs to take place. And that can only be determined in the future. And that places a burden on, or some difficulty with the practitioners to try and conclude the business rescue proceedings within the specified period of time. Also, what one sit with in terms of SARS is where it becomes difficult for SARS to collect a tax liability. SARS would ordinarily go and determine, and is obliged to do so in terms of just 1 second, please, gentlemen. Is to, sorry for the delay in that, in the breakup there, is to approach a business rescue in terms of section 201 to 203. Now, if you're a little bit versed with, or if you're versed with the tax legislation, that is ordinarily the provisions that you go to secure a full and final settlement, termed otherwise as a compromise. And the Act is very specific in terms of the consideration SARS needs to keep in mind when it does consider or participate in a business rescue. Amongst other things that they need to consider is what is the greatest amount that it can recover in the shortest possible period of time, and is there any other measures that they can employ, alternatively institute, to recover those amount, any tax amount from the taxpayers. Also, there's under section 203, there's quite a few disqualifications. Most notably, the most important one under 203 would be the personal liability of directors for unpaid taxes. Now, SARS by law under 203 is not allowed to compromise any tax liability unless it hasn't first considered the personal liability of the directors of the company, which is a very, very difficult process in itself to pursue. I think it's different in tax law. It's different, quite different from the process that is followed in the Companies Act through the piercing of the corporate veil. In terms of tax legislation, there's, amongst other, section 155 that deals with that in terms of the representative taxpayer, and also section 180, which takes the process a little bit further to say that any person that was in the financial management and or control of the business at the time that liability was incurred or whilst it remains unpaid. One would ordinarily need to prove under those circumstances that there was a willful and deliberate decision not to pay any tax. Now, that's easy for SARS to conclude on the basis that there's business rescue proceedings, and they point blankly just attribute that liability to the directors. So that is something that will come up more often. We see that in ordinary collections measures that SARS is now being more aggressive on the personal liability front. Directors often, or most recently, get notices of personal liability where SARS say that we deem you to be liable for the unpaid tax debt, and you must give us reasons why you are not liable. And that will ordinarily also impact on the business rescue proceedings in terms of tax. I think what's a good process, and some of the business rescue processes that I've been involved lately, is where the practitioners have incorporated alternative dispute resolution measures once there's a dispute pertaining to the tax liabilities. SARS has started to where they were reluctant to either participate or reserve their vote in business rescue plans, in terms of those plans, to start participating in those plans and actively engaging practitioners to find some sort of way where they can recover either a portion of the liabilities to be compromised, or in ensuring that the taxpayer remains compliant and that the business rescue is actually successful. A few of those measures is the following. Sorry, I just want to get my place again. Is that in these ADR, what we have found in these ADR processes, what SARS does is SARS is insisted there on that a practitioner must include 4 specific clauses within its business rescue plan. And the first clause that they are insistent on is that there must be compliance with the terms and conditions of the business rescue plan as a whole. They further stipulate that if there is any non-compliance with any term within that agreement that negatively impacts the outcome of the business rescue plan, that it will be, and it's termed in their clause as to be deemed to be terminated. A second clause that they insist upon is that a tax compliance clause, compliance with it, and that's just compliance with tax obligations, i.e. all tax returns must be submitted, post-commencement tax returns must be submitted and paid. And if not done, SARS views it as that the business rescue proceedings has been terminated. A fourth clause that we're dealing with that SARS insists upon is the VAT clawback. This is quite a contentious issue with SARS in every business rescue that we're dealing with. Essentially, what SARS is insisting on is that under Section 22 of the VAT Act, any tax liabilities that is or any liabilities compromised with a creditor that had a VAT implication, the amount that was compromised, there is VAT payable on that amount. And ordinarily, SARS holds the view that such an amount is a post-commencement liability, which is not subject to compromise and paid in full. Now, most, if not all, of the practitioners that I consult with hold a different view in saying that it is a liability that originates from pre-commencement liabilities, is settled in terms of the business rescue plan, and therefore it cannot be a post-commencement liability and must be dealt with in terms of the business rescue plan as a pre-commencement debt. And SARS must accept a similar dividend as it would for any of its other claims. The last one that they insist upon is that there will be a forfeiture of assessed loss or any other benefits should SARS accept the business rescue plan and should the tax debt be compromised. And they further stipulate, and they haven't been like this previously, is that they will the assessed loss will be forfeited in accordance with the tax liabilities being compromised. I.e., if you have got a tax liability of 500,000 rands and you compromise at 50 cents in the rand, there's 250,000 rand is remaining. You have an assessed liability, assessed loss of 1 million rand. Ordinarily, your 1 million rand assessed loss will be reduced by the 250 that has been written off, and the terms will clearly be stipulated. SARS is not really open to negotiations to have these clauses amended. In most, if not all, of the instances where we engage SARS on these 4 clauses, they try to keep it as close to what the initial wording of these clauses are. And often, if no agreement is reached, they will default to a vote against the business rescue plan. And that also is depending upon the claim that they have in the business rescue. What we are seeing going forward is that SARS will have to ask the business rescue practitioners to, as a type of a sweetener in the business rescue plan, to look at how the initial report of the business rescue practitioner was compiled, and to determine how this entity actually ended up in the financial distress. Did they take the necessary measures to investigate the conduct of the directors and the shareholders within the business? And to what extent did that contribute to the company incurring the tax liabilities? Was it due to any misrepresentation, negligence, and or fraud? And was any steps taken? And the reason being is that, once again, coming back to personal liability, which SARS is using as a very effective tool and will continue to do so, is that where any amount will be compromised, SARS, as my personal view, will definitely look at that portion of tax that will be compromised can then be recovered from those directors, depending on what the circumstances and the facts to the incurrence of the liability was. And that actually takes the case, or that part, out of the hands of the business rescue practitioner and allows SARS to proceed uninhibited to collect that, attempt to collect that amount. That is obviously open for litigation from the director side, but that is the consideration to the directors personally and specifically. I think that is, in short, that is my presentation, and seeing the standing of business rescues and SARS. I will forward my presentation to Jonathan tomorrow morning early, so that everybody can have access to it. If there's any questions pertaining to the presentation, I'll be glad to answer any of those just now.
Awesome. Thank you very much, Johan. I see we are running a little bit short of time, so let's get into some of the questions. Roxanne, let's start with you. You pointed out that business rescue legislation has been around for 13 years. You also then made a statement saying that whether 13 years is long enough for BRPs to get to know the legislation is a different debate altogether. Can you just discuss this in a little bit more detail?
Thanks, Jonathan. I think the point there is that some people may say, well, 13 years is quite a long time. And it is, but I think you need to take each case as it comes. And every case, there's new issues, novel issues that arise, nuances, interpretation that need the assistance of the court to clarify those issues. So it's good and well to say that it's been 13 years, it's not a new company, it's not recently new. We already know about business rescue. Each case is different. Like, take, for example, the ComAir. You had lease agreements concluded where the aircrafts were operating in South Africa, but the aircraft lease agreements were based on the jurisdiction of English courts. You also had to recognize the business rescue proceedings in foreign jurisdictions. So in each case, there's new issues that arise that need assistance of interpretation, and the courts do assist us. So that's what I meant with that statement.
Thank you very much. Jessica, maybe over to you. You mentioned in your talk, a couple of times that, there are labor issues, and there are sort of instances where a lot of employees of a company are going to get affected. If we move on and we consider that more SOEs are going to go into business rescues in the future, you're going to have the interplay of labor unions coming into it. And obviously these parties or stakeholders would want the business rescue practitioner to publish something with regards to how many retrenchments are going to take place and what their plan is regarding that. How much of this is going to be generic in the future in order for business rescue plans to be published, as opposed to saying, hang on, this is going to be a stumbling block, and then the process gets delayed?
Absolutely, Jonathan. So yeah, that's exactly the concern that was raised with the judgment flowing from the SIA judgment, was that there is concern that BRPs are going to kind of feel, that they may feel obliged to kind of develop a more generic, or as we say, like a vanilla plan, simply to get it passed, just so that the company can go ahead and start retrenchment processes. But I mean, already, with the enthusiastic unions that we have in this country, it's already to get buy-in as it is very difficult in the business rescue process, in considering the meetings of creditors, meetings of employees. And so I do think that this does pose some difficulties in getting buy-in, especially when, as you said, you are now publishing the fact that there is retrenchment is contemplated, which, I mean, when you're dealing with people's livelihoods, I think, it's obviously a very, very sensitive topic. And so I do think that it can cause or pose the risk of further frustrations in the implementing of the plan, and getting buy-in from all the various stakeholders. And so, so I think that'll just be something that we'll have to see play out in the future.
Just in interest of time and giving all of our panelists an opportunity to answer one question, I'm going to ask Johan one more question and then maybe post some more questions to do, maybe a written article with the other questions between Roxanne, Jessica, and Johan with the other ones. Johan, we know that there is sort of a feeling of general tax abuse in South Africa. Do you think that this is a concern or a practice that's happening in business rescue? Can you please discuss this?
Jonathan, I don't think that it's a practice that happens in business rescue. I think a business rescue practitioner inherits quite a lot of problems in business rescue pertaining to a company's tax affairs. I think it makes it extremely difficult to manage the business rescue process in dealing with, like I mentioned, the specifically when assessments comes about. I think SARS already, when a company goes into business rescue, with the history that they have, with the non-compliance, they've had their engagements with the taxpayer. They've started with their collections actions. They've had their final demands. They did their third-party appointments. Often they have already taken judgment. So they have a perception that there was non-compliance, and often they feel that it's the business rescue is a process to either delay or avoid paying tax. So I think in terms of business rescue, to answer your question and to summarize it, I don't necessarily think, in my experience, none of the practitioners that I've been dealing with sees it as a practice to avoid paying taxes. All of them tries to comply and to get the company tax compliant as far as they can. Often it's due to the requirement for a tax clearance certificate. Otherwise, they can't trade or they can't recover their monies from whoever they need to. So no, I don't think in business rescue in general, I don't feel that's a general practice, but I think there is some instances where it is a little bit of a problem.
Thank you very much, Johan. As pointed out, I will ask additional questions via email, and I will put in an article which I will publish on my website and let you know more about that via my LinkedIn platform. Let me take this opportunity to thank my panelists and participants for taking part and taking the time to join me in the roundtable. A recording of this roundtable will be posted on the Turnaround Talk website later this week. We are planning to hold another roundtable in November, and until then, thank you for joining us, and keep safe, guys. Thank you very much.